The time for this debate has expired. I call on Government Order of the Day number 1.
Children, Young Persons and Their Families, Advocacy, Workforce and Age Settings Amendment, Committee stage.
I declare the House in committee for consideration of the Children, Young Persons and Their Families, Advocacy, Workforce and Age Settings Amendment Bill. Mr Chairman.
Mr Speaker. Members, the House and Committee on the Children, Young Persons and Their Families, Advocacy, Workplace and Age Settings Amendment Bill. A point of order, Tim McIndoe.
Mr Chair, with the agreement of the whips across the House, I seek leave for the committee to consider all the clauses of the Children, Young Persons and Their Families, Advocacy, Workforce and Age Settings Amendment Bill as one debate, with the voting on the clauses to be taken separately.
Leave is sought for that purpose. Is there any objection? There is no objection. Then, members, the question is that clauses 1 to 11, schedules 1 to 3 stand part.
Mr Chair.
I call Jacinda Ardern.
Thank you, Mr Chair. I want to begin the committee stage debate by again starting where Labor started in the second reading debate, and that was to point out that we have long had a desire to be in a position to support this bill, but really the committee stages will determine whether that is going to be possible for us or not. We have long advocated for the clauses in this bill which allow the age of care and protection to be increased. In fact, we would have liked to have seen the age overall be increased, both for the age of care and protection and youth court jurisdiction, but accept that half is better than nothing. However, Mr Speaker, as I outlined in our second reading speech, that proposal has come at a cost. In the same bill where the government has done an excellent thing by increasing that age of care and protection, which we've pushed for 8 years now, they are also proposing to allow very permissive powers to the Chief Executive to delegate what currently only social workers and the New Zealand Police Force are able to do under our laws. We have an SOP I want to flag now, Mr Chair, up front, before I delve into committee stage debate. We have an SOP that would essentially delete Clause 7, all of the powers that allow the Chief Executive to delegate the powers of social workers. We don't feel there's adequate explanation or constraint around those powers, and our support of this bill beyond committee stages will be contingent on that SOP succeeding. So we've made that view known in the second reading debate. I've made that view known personally to the Minister's office. We have wanted to be as constructive as possible because of our support for elements of this bill, but this could not be at the cost, the massive cost that the government has asked us to make those changes. And I also want to state up front that if it comes to that, and we'll be very disappointed if it does, if it comes to that, it will be with great sadness, because we have walked alongside the likes of the Dingwall Trust and LifeWise to see this point and the age of care and protection raised. I want to come specifically, though, Mr Chair, to Clause 4 of the bill, because Clause 4 both enacts the raising of the age for care and protection, but it also highlights the difficulty we're creating ourselves by having two distinct age ranges within our Children, Young Persons and Their Families Act. So Clause 1 sets out that in Section 2(1) will replace the definition of young person, and parts 2 to 3A means a person of or over the age of 14 years but under the years of 18. In parts 4 and 5, it means a person of or over the age of 14 years but under the ages of 17 years. So this Act is basically saying that there are two different meanings to the word young person, that a young person can be two completely different things, that for the purposes of care and protection, which under the SIFS Act is set out in parts 2 and through to 3A. Then we'll agree that a young person is 18 years and under. But for the Child, Youth and Family Act, parts 4 and 5, which are all the clauses that relate to the youth justice system, oh, you're not a young person till you're 18, you're a young person to 17. That makes absolutely no sense. If we believe there are grounds to consider that a young person should be someone under the age of 18 years, then we should be consistent about that. There is no rationale in this bill to say that we consider you a child for care and protection, but we do not consider you a child for the criminal justice system. And I want to be very clear here that if we are looking for a rationale, a consistent one, there should be one no greater than the United Nations Convention on the Rights of the Child. That is the guiding principle that says to all countries, not just New Zealand, a young person is a child if they're 18 years and under, and we should treat them that way. Not least in care and protection, but if you're going to have that convention, that perhaps the most important measure of a society is whether you're willing to do that in your criminal justice system, when you have the ability to imprison. So, Mr. Chair, in terms of the practicalities of what these split definitions mean here in Clause 4, essentially, we could have a situation because, Mr. Chair, because parts 2 and 3A of the SIFS Acts relate to care and protection family group conferences, but often those family group conferences aren't just dealing with care and protection issues, often they will deal with youth justice issues, that we could have a situation where you can have a family group conference around the future care and protection needs of a child, but you won't be able to discuss any criminality that might be involved because that could only be dealt with in a district court. We've now split this young person in two based on an arbitrary measure of their age. Now, we are firmly of the view that Andrew Beecroft, who's our Children's Commissioner but had been Chief Youth Court Judge, that you cannot do that in any functional system, that we need consistency, and that the youth court is not a soft touch. It is the best option for a person in that age group in terms of rehabilitation, the ability to restore, the ability to prevent a young person staying in the system. So we're not just saying this because we believe in the rights of a child, we're saying it because the outcomes are better as well. The outcomes are better. So we have an SOP as well, Mr. Chair. That's SOP number 248, which will bring consistency to what is currently two split definitions in Clause 4. Having said that, I will highlight that although we wanted a raise generally, we will vote for the clause that allows the care and protection age to be lifted because we do support that happening. I want to come now to Clause 6. This gives an amended set of duties to the Chief Executive around giving consideration to the needs of those in care. So basically giving a chance for a young person to express their views around the services they receive, basically around what happens to them. Now, the point we just wanted to make is that we absolutely support these clauses. We'll be voting for them, but we really wanted to give a bit more clout to them, put a bit more responsibility to the Chief Executive to make sure that they're actually happening. And one way that we thought we could do that was to publish annually what action had been taken to make sure that the views of children were being taken into account. So we are going to pop that in, attempt through our SOP into the bill as well. I think it was, if memory serves, in Select Committee it was a suggestion from the Children's Commissioner, which we thought made absolute sense. Not least because the Children's Commissioner has an advocacy for children's role at present, and they do a very good job, but it is very difficult for them on their roughly $2 million budget to play the advocacy role they would like to play, to give children that voice. Now, we're adding new functions in here, but there's been no suggestion as to how that would be funded. It's our view that if we put in a requirement to report to Parliament, we would have a very acute eye as to whether or not we were doing enough to operationalise what is here in the legislation around giving children a voice. Keeping in mind that, of course, the Children's Commissioner in recent times has had to close offices, has had to reduce visits to residential facilities, which is a legislated function that they have from 1 year to 18 months because of the financial constraints that they have. So if the intention is that the Children's Commissioner is the one to operationalise some of these checks and balances that children in care are having their voice heard, then they are absolutely under-resourced to do that job. So I would be very keen to hear the Minister and the Chair's view on what opposition would there be to simply putting in a requirement that we just report on the first anniversary of the commencement date on how well we've been doing in giving young people a voice. I think it seems like a fairly common sense provision to me. Mr. Chair, I want to come to Clause 7. This is where a number of our most significant concerns lie. I imagine it's something that I will need to continue a call on. We raised in the second reading our concern with these clauses. This entire section allows the Chief Executive to delegate social workers' powers to anyone they are satisfied meets 3 basic tests. Now, the first requirement is that they meet Section 41 of the State Sector Act 1988. I've looked up Section 41 that mostly relates to what you practically need to do to delegate any powers as a ministry. And basically, in summary, it says the minister has to approve it and you have to write it down. That's basically what Section 41 is. So not too dissimilar to what's noted in the bill itself. But Mr. Chair, I'd like to come back in another call to speak more on this.
I'm calling Jan